I think that's what the state does in a great many filings. In criminal complaints, for example, we put forth what we believe the evidence shows. Of course, there are allegations, and I can't prove this beyond a reasonable doubt at this point that Ms. Krzyzewski wrote it. I can say that it came to our attention. We wanted to give the court ample time to review these documents. We were not just going to assume that at the time we filed these, sentencing would be adjourned automatically, so we've given the court a week with these documents from our filing date, and the detectives have been working hard to answer all of those questions the court has, and frankly the state has, and I'm sure the defense has. We just haven't been able to solve some of those answers, but we thought it certainly relevant that these were written on the back of trial notes, that they're dated, that they're made to look like certain pieces of evidence the state put forth as fraudulent during trial. Obviously they're not those items because they were written on the back of trial notes. The letter purports to be from Jessie. She signs her name. I'm no handwriting expert, but the writing looked similar to what we had seen from her handwriting. And she's the only one to gain from having somebody file the things that are requested. A tape recording of Lynn Hernan admitting to being suicidal and essentially putting together a suicide tape and sent to your honor from a concerned citizen with no return address. The envelope itself, the return address portion is a person we know to be very good friends with Ms. Krzyzewski, and we've of course redacted her name and address so it doesn't get out there inappropriately, but that's not something we believe a great many people that could have just picked up Ms. Krzyzewski's trial notes would know, and even know to include as the return sender. Now detectives have gone and talked to that individual, and she claims to know nothing about this at all. So we may be left with no answers. At this point we don't have them, and I don't know that I don't know what % likelihood I can put on it. I know Detective Plennis informed me today that he's had hours upon hours of jail camera footage put onto a hard drive. I believe it's taken up quite a bit of a hard drive so that it can continue to be reviewed to see if that lends any clues. But knowing that sentencing was today, it was absolutely filed so that this wasn't a last second request for the court to review 37 pages and spring it on everybody as to what the state thought this was. I thought it fair to everybody to put forth the state's position along with the documents itself, along with the opportunity to review the originals. Because they were double-sided and a single-sided copy, it took the prosecutor team a little time to figure out a single-sided copy on what we were looking at until Detective Plennis had time to sit down and show us the originals. So we first offered that to the defense team before filing with the court with what I would call a guide as to how to read it, given that we could not just bring over the originals to your honor ex parte and show you them.
Have you had an opportunity to discuss the motion to withdraw with the victim?
We have. Our victim witness advocate has been keeping them informed really over the past week as all these filings have come in.
Does Mr. Posa have, because of the count 3, does he have a position on this or wish to address the court in any way in compliance with victim rights?
You want to address the court? Yeah. Your Honor, I've confirmed with Mr. Posa, who's present in the court, that he does not wish to address the court, but he's obviously very opposed to this. He's been opposed to a great many of the continuances in this trial, understanding that a lot of them are necessary, but certainly there's a great interest in finality to this case.
Attorney Kukler, I'll ask this to both you and Attorney Galaviz, but I want to make clear that I understand the basis for your request is you believe that, or let me state it this way, your request is made under SCR 20:1.6 sub, that's parenthetical B? Do I understand your request correctly?
Yes.
And without divulging confidential information, you have made that request because you believe there's an actual conflict of interest here.
I do. I believe that. And you know, this court knows me from many years of practice and know that I rarely, if ever, have withdrawn from a case.
Thank you. Attorney Galaviz, same question or questions to you. Your request is under SCR 20:1.16, parenthetical B.
Correct, and the state bar ethics told me to cite A as the reason, but B could also be used. It's an obvious conflict.
You have cited actually A and B, and you did, as your motion states, you did consult with the ethics individuals at the state bar.
Correct.
And they made a recommendation to you?
Correct.
Attorney Kukler, did you do anything like that, or did you rely upon what Attorney Galaviz had done?
That's right. I relied upon what he did.
These types of motions are always difficult for the court, especially when the court has not only presided over what was a trial that lasted almost 4 weeks, many motion hearings, significant motions related to the experts in this case, and a case such as this where we don't really have any more significant crime than the crime of first-degree intentional homicide. And it's difficult because, like I said earlier, I don't want to set a precedent that simply leads someone to believe that you make an allegation against an attorney and that's enough to get that attorney off the case. Oftentimes, when we're in the beginning stages of litigation, there's a little bit more leniency when it comes to these types of issues, and this is, I can't say unique, but the circumstances here are important to note that there has been a trial and a significant trial and significant litigation for a very serious crime, and in fact more than one crime for which Ms. Kershevsky has now been convicted. And lawyers, all lawyers have, in addition to their obligations, for example, for a defense attorney to their client, but all lawyers have the responsibility to be truthful with the tribunal, to have candor. And then, of course, there's all of these confidentiality requirements that apply to Attorney Kukler and Attorney Galaviz. And there's very, very limited circumstances that a lawyer is obligated to reveal information and then even permissively required to reveal information. And I mentioned this earlier, and I took a look at that, and I honestly think when you look at it, it's really a stretch. I know I mentioned it, kind of to ask a probing question. It's kind of a stretch, though, to say that there's any requirement or even permissively that allows Attorneys Kukler and Galaviz to reveal information. They're officers of the court. They believe that they have an actual conflict of interest, and they've asked to withdraw. I know from my review of the Supreme Court rules that part of the ethical considerations aren't only to maintain that confidentiality, but obviously lawyers may not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. But a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. And so, I'm mindful of that. I'm mindful of the rule that's been cited, which is why I asked for confirmation from the lawyers. SCR 20:1.16, terminating representation, sub A states that, except as stated in paragraph sub C, a lawyer shall not represent a client, or where representation has commenced, shall withdraw from the representation of a client if the representation will result in a violation of the rules of professional conduct or other law. Sub B, again, except as stated in paragraph C, a lawyer may withdraw from representing a client if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. The client has used the lawyer's services to perpetuate a crime or fraud, or four, the client insists, sub 4, even though it's not the fourth one I've read, the client insists upon taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement. I'm also mindful of what this filing actually contains. And when I reviewed it, it's not just a single reference to the attorneys, but on page 2 of what I would call kind of the cover letter to this document, it states as follows: even this envelope didn't go out through jail mail. My attorney took it. This was one of my attorney's ideas, and clearly they aren't going to tell anyone. On the second page, which is the third page of that cover letter, but the next page after that, it says, we are trying to make a stir, a big stir, to show just how wrong they are. Again, very general. And those are the references, I guess, to counsel. This filing clearly raises a concern for the court because whomever wrote it, and I think I do need to consider for purposes of this hearing that one possibility is Ms. Krzyzewski, is requesting another person to engage in fraudulent and likely criminal activity related to the fabrication of evidence. It's been provided by the state as a request that I consider it at the time of sentencing under my authority and the criteria that I am obligated to consider, right? The 3 primary sentencing consideration, the Galleon factors, one of which is the character of the defendant. That's why the state has presented this information. This information, though, it presents many more questions at times than answers, some of which we've already discussed, including the fact that there is no postmark over the postage. There is what appears to be a stamp from the Waukesha County Jail. I'm now told, and I didn't, I guess, catch this during my review, is that envelope has a crease in it, whereas in all the other documents within it do not. There is information within that filing, as has been explained here today, where there's a verification that they are contemporaneous notes. Attorney Kukler indicated she recognized either her own or Attorney Galavi's handwriting on it, so there's some legitimacy as to how, or when I should say, that was part of this exhibit or this document was created, right, contemporaneously with the trial or during the trial. When I consider all of that, I think I am left with the inescapable and unenviable decision here today to make a finding that at a minimum there's a serious potential conflict of interest, perhaps even an actual conflict of interest. Looking at the authority in State versus Miller, this court must presume prejudice to Ms. Krzyzewski in requiring her attorneys to represent her going further. She does not have an objection. I think there's an additional basis that there has now been a serious breakdown of communication and a difference of objectives between Ms. Kershevsky and her counsel, that this is a relationship that cannot be mended. And even though it means that this sentencing hearing must be adjourned and that new counsel be provided for Ms. Kershevsky, I am going to grant with reluctance, but I think it's the right thing to do, the motions to withdraw by attorneys Kukler and Galaviz. Rather than reset a sentencing hearing today, knowing that this was a very lengthy trial for which transcripts may very well need to be obtained, and or new counsel review the live stream recordings that are available online of the trial itself, certainly talk with Ms. Kershevsky, maybe even talk with attorneys Kukler and Galaviz at a minimum, get all discovery information from them. And last but not least, to give the state an opportunity to fully investigate this issue and present more accurate information to the court at the time of sentencing. I do believe it relates to a legitimate sentencing consideration, but as it states right now, this filing, I think, presents some more questions than answers, and I think more time also gives the state an opportunity. I have to be mindful that both sides have the right to a fair hearing at sentencing. And it would likewise be unfair, I think, to the state if I simply said this isn't coming in as well. I will let them argue it, present it, and any additional information on it at the time of sentencing. New counsel can certainly object, and it, of course, will be up to the court at the time of sentencing to put whatever weight, if any, on that as I consider which or how to impose sentence on Ms. Kershevsky for all of these offenses. Given that it is early December and we have some holidays coming up, given that it may take some time for the Public Defender's Office to appoint, because she does qualify and will continue to qualify, I will set this over to early January for status of counsel. I believe, Attorney Kukler, you filed a proposed order. Attorney Galaviz, did you file one as well?
Yes, Judge.
All right, then those both should be on my dashboard. I'll look for those, I'll sign them, and that will then trigger the Public Defender's Office. Attorneys Kukler and Galaviz, what I ask is that you cooperate with whomever is appointed and work with them at getting all discovery to them, and all information and notes that you have from trial to that attorney or attorneys, if that's the case, and do that as promptly and efficiently as possible so that there can be the fewest delays going forward.
Yes, Judge.
For purposes of the next hearing, although I'm allowing you to withdraw, if discovery has not been turned over to successor counsel, I'm requiring both of you to come to that next hearing with discovery that you have, just in the event it didn't take place. It's my way of enforcing that.
We will send ours electronically to whoever is appointed.
Even including trial notes and things of that nature that you would give to successor counsel?
We have everything ready electronically for
Okay, very well.
counsel.
Then I'll take your word as an officer of the court that that will be done, and that can probably be done very quickly then. But again, if it for some reason hasn't happened, then one of you at least should be here. Would everyone be available on Friday, January 12th at 10:30 a.m.?
That works for the state. Oh, I'm sorry.
Okay with me?
Yes, that's good.
All right, that will be for status of council and for further scheduling. And again, I'll, as soon as we're done here, look at those orders. I'll let you know if there's an issue with them, but presumably I'll sign them and we'll go from there. Thank you, everyone. That does conclude the hearing.
Thank you.
And we'll be in 10:16.